And if you'd like, we could go ahead and start the live stream.
Very good. We'll give Julie just a moment to get that going, and I'll let you know when we're good.
This conference will now be recorded.
We are now live streaming, and you may begin the meeting, Dr. Bechtel.
Well, good morning. The time is 10:01, and the May 12th, 2021 meeting of the State Medical Board will come to order with the following members present via video conference. Dr. Rothermill?
Present.
Thank you. Dr. Safran?
Present.
Thank you. Mr. Gacaloni?
Here.
Thank you. Dr. Soin?
Present.
Thank you. Dr. Schonstein?
Here.
Thank you. Dr. Reddy?
Yes.
Good. Thank you. Dr. Johnson?
Here.
Good. Thank you. Dr. Coccarella?
Dr. Coccarelli, you're there. I think you're unmuted now.
Okay. Present. Thank you, sir. Ms. Montgomery? Dr. Feibel?
Here.
Thank you. And myself, Dr. Bechtel, here. Do I hear a motion to approve the minutes of the April 14th, 2021 board meeting and the March 30th, 2021 special meeting as drafted? Do I have a motion?
So moved.
Dr. Safran, do I have a second? Dr. Coccarella, thank you. All in favor, say aye.
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 Opposed, say aye. The motion passes. The board will now consider the reports and recommendations appearing on today's agenda. Has each member of the board received, read, and considered the hearing record, the findings of fact, conclusions, and proposed orders, and any objections filed in the matter of Brian Reed Lee and Paul Yang, MD? Roll call. Dr. Rothermill?
Yes.
Thank you. Dr. Safran?
Yes.
Mr. Gacaloni?
Yes.
Dr. Soin?
Yes.
Thank you. Dr. Schonstein?
Yes.
Thank you. Dr. Reddy?
Yes.
Good. Dr. Johnson?
Yes.
Thank you. Dr. Coccarella?
Yes.
Yes. Okay. Ms. Montgomery?
Yes.
Thank you. Dr. Feibel?
Yes.
Thank you. And myself, Dr. Bechtel, yes. Further, does each member of the board understand the board's disciplinary guidelines do not limit any sanction to be imposed, and the range of sanctions available to each matter runs from dismissal to permanent revocation or permanent denial? Roll call. Dr. Rothermill?
Yes.
Dr. Safran?
Yes.
Mr. Coccarella?
Yes.
Dr. Soin?
Yes.
Thank you. Dr. Schonstein?
Yes.
Dr. Reddy?
Yes.
Dr. Johnson?
Yes.
Dr. Coccarella?
Yes.
Yes, thank you. Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Thank you. And myself, Dr. Bechtel, yes. Does each member of the board understand that in each matter eligible for a fine, the board's fining guidelines allow for the imposition of the range of civil penalties from no fine to the statutory maximum amount of $20,000? Roll call, please. Dr. Rothermill?
Yes.
Thank you. Dr. Safran?
Yes.
Mr. Gacaloni?
Yes.
Thank you. Dr. Soin?
Yes.
Dr. Schonstein?
Yes.
Thank you. Dr. Reddy?
Yes.
Dr. Johnson?
Yes.
Thank you. Dr. Coccarella?
Yes.
Thank you. Ms. Montgomery?
Yes.
Thank you. Dr. Feibel?
Yes.
Thank you. And myself, Dr. Bechtel, yes. In accordance with the provision in Ohio Revised Code 4731.22 F2, specifying that no member of the board who supervises the investigation of the case shall participate in further adjudication of the case. The secretary and supervising member must abstain from further participation in the adjudication of any disciplinary matters. In the disciplinary matters before the board today, Dr. Rothermel served as the secretary and Dr. Safran served as the supervising member. In addition, I, Dr. Bechtel, served as the secretary and/or supervising member in the matter of Dr. Yang. During these proceedings, no oral motions may be made by either party. Finally, respondents and their attorneys addressing the board will be allotted 5 minutes to do so. The board parliamentarian will advise when the 5 minutes has expired. The assistant attorneys general will be subject to the same limitations. Now, please turn to the matter of Ryan Reed Lee. No objections have been filed, and Ms. Szymanski was the hearing examiner. The request to address the board has been filed on behalf of Mr. Lee. 5 minutes will be allowed for the address. Mr. Lee, please go ahead.
Good morning. My name is Todd Newkirk. I represent Mr. Lee in this matter. I just have a few remarks before turning the majority of the time over to Mr. Lee. First, we'd like to thank Ms. Szymanski for her work and her thorough R&R in this case. After hearing all the evidence, she recommended that Mr. Lee's license to practice massage therapy be granted and that he be immediately suspended for a minimum period of 60 days. She also recommended an ethics course as well as a period of 2 years of probation after reinstatement. We submit that that recommendation is fair and appropriate in this case, and we ask the now.
Good morning. At this time, I'd like to thank all of you as board members for taking this time today, as well as previously, to review my case in its entirety. I'd like to thank Rhonda Szymanski as well. I believe she gave a fair diagnosis of what I was looking for. And I guess along those lines, just to reiterate, I basically the premise, one of the questions basically is, am I a good candidate and why? And that's probably still a question that is still out there amongst all of us. But at this time, I believe I am and plan on doing good things, hopefully by approval by this board, granting my license. I'm sure as all you members of the state medical board who represent and also represent the state medical board know the difficulties of achieving these accomplishments, obtaining your license, but even prior to that, just basically achieving the grades and the coursework. So, and I put forth a great deal of effort. I wasn't a student by far, but I basically applied myself. And so in doing so, I basically did that then and during my life, and hope to do the same as a massage therapist with the board's approval of Ms. Szymanski's recommendation. Again, I'd like to thank all of you as board members, and I appreciate your time and consideration in this matter.
Thank you, Mr. Lee.
You're welcome.
Does the Assistant Attorney General wish to respond?
We do not have a response. We would defer to the report and recommendation. Thank you.
Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Mr. Lee? Do I have a motion?
So moved, Dr. Johnson.
Thank you, Dr. Johnson. Second by Dr. Coccarella. I now entertain discussion concerning the matter of Mr. Lee. Is there any discussion? Dr. Schonstein?
Forgive me, I think Ms. Montgomery was going to say something.
Oh, I'm Ms. Montgomery.
No, I just wanted to congratulate Ryan Lee on persevering, and you've got a few hills to climb here, and we wish you all the luck in the world. I happen to agree with the decision to frankly give you a second chance. And I suspect when we look at you got your license in a year and you had a 4.0, you may not have been a student, but you had something more that's important, which you had stick-to-itiveness and I hope personally, I hope that you'll persevere and get past this. And don't forget that, as your lawyer will advise you, there are you may or may not qualify for expungement at some point. So good luck to you. That's
Thank
my
you.
personal.
Thank you. Dr. Schottenstein?
I'll just add that, the gentleman did plead, of course, to the 5th degree felony of receiving stolen property and was represented by counsel, of course. And so this is a case of mitigation. In mitigation, there's no prior disciplinary record. I think this is an isolated incident that's unlikely to recur. He's made free and full disclosure to the board. And in her closing argument, the Assistant Attorney General described him as forthcoming and truthful. And of course, he's expressed remorse and responsibility and taken responsibility for his actions. I also agree with the hearing examiner's opinion that culpability was low. I think the conduct was negligent but not reckless. So I also support the proposed order.
Thank you. I'd like to have now a roll call vote to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Mr. Lee. Roll call, Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
thank you. Mr. Cacaloni,
Yes.
Dr. Stoning,
Yes.
thank you. Dr. Schottenstein,
Yes.
Dr. Reddy,
Yes.
thank you. Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
yes. Okay. Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
yes. And myself, Dr. Bechtel, yes. Thank you for your time, Mr. Lee, and you may exit the video conference now. If you wish to view the rest of the public meeting, it'll be live streamed on the board's YouTube channel. Thank you.
Yes, thank you, sir.
Thank you.
Good luck.
Thank you.
We'll now turn to the matter of Paul Yang, MD. Objections have been filed and were previously distributed to board members. Mr. Porter was the hearing examiner. A request to address the board has been filed on behalf of Dr. Yang, and 5 minutes will be allowed for that address. Dr. Yang, would you like to proceed?
Yes. Good morning. My name is Jim McGovern. I represent Dr. Yang. I'm going to let him get started, and then I'll finish with a few words. Dr. Yang?
Yes, can you hear me?
Yes.
Okay. Good morning. My name is Paul Yang. I'm pleased to have the chance to address you today regarding Ms. Szymanski's report and recommendation. I wish, however, I was addressing you under much different circumstances. I love my profession and the patients I had the privilege to care for. That's why I am embarrassed and ashamed as I sit here today, knowing that I betrayed my patients and the medical profession through my upcoding. I realize I cannot go back in time, but if I could, I never would have engaged in the conduct that led to my conviction and that places me before you today with my Ohio medical license in your hands. As I am today, I was very nervous leading up to the February 2021 hearing, but Ms. Szymanski and Ms. Pelfrey were very kind in making me feel as comfortable as possible. And for that, I would like to publicly thank them. Except for a few objections that will be addressed by Mr. McGovern, my attorney, I support Ms. Szymanski's report, and I appreciate that her recommended sanction at least left the door open for me to someday return to practice of medicine in Ohio. Since receiving the September 2020 notice of opportunity for hearing, I've strived to cooperate with the State Medical Board of Ohio and to demonstrate sincere contrition for my illegal conduct in the same way that I did in dealing with the United States during their investigation and my criminal case. I take full responsibility for my actions. I sincerely apologize for the harm that I caused to all who are negatively impacted by my conduct. Before you decide what to do with my license, I want you to know that I've learned from my mistakes. My criminal conduct occurred when I was employed by Dr. Sharma's practice. After that, I practiced medicine for Heritage without incident from 2012 into 2018. In 2018, I worked non-medical positions to try and support my family, always earning far less than I did as a physician. In evaluating the type of person that I am now and the character I exhibit, I encourage you to please consider the testimony offered by Matt Shimperly, my boss with Everett Agencies of Ohio. I have been humbled by the sequence of events, starting with the criminal investigation and ending here today. Since 2012, I have not violated the law. Today, I want to pledge to you that regardless of what I do to earn a living, I will continue to follow my straight and narrow path as a hardworking, honest, and law-abiding citizen. I have come to understand the need for complete honesty in all facets of my life. I recognize that honesty is essential in my dealings with this board and whenever I'm allowed to return to practice of medicine in Ohio. If you chart the path for me to be able to return to the practice of medicine in Ohio, I will be grateful, and I promise I will do exactly what is required of me to remain in full compliance with the Ohio Medical Practice Act. Please give me a chance. Thank you for your time.
Thank you, Dr. Yang. Mr. McGovern?
Yes, members of the board, Dr. Yang has expressed true remorse and he's taken full responsibility for his actions. He received a fair hearing, and I trust you reviewed his brief and limited objections to the hearing examiner's report and recommendation. Will not rehash those objections other than those related to the proposed sanction. In deciding upon a sanction, strong consideration should be given to the remoteness of Dr. Yang's conduct at issue, which ended in 2012, along with the steps he's taken since to be a better physician and a better person overall. The board should also factor in that other than maintaining his employment with Dr. Sharma, Dr. Yang received no additional benefit, financial or otherwise, from the upcoding he engaged in. The upcoding was clearly illegal and involved dishonesty. However, since being confronted as part of the United States investigation, Dr. Yang's been 100% honest with the United States through the investigation and criminal case, and then with this board. That included his proffer that the U.S. Used to help convict Dr. Sharma, who was a ringleader in the upcoding that occurred in his practice. The board's urged to consider, please, all of the mitigation evidence that's set forth on pages 16 through 23 of the report and recommendation, including all of Dr. Yang's community service, and to please consider imposing a sanction that does not include the revocation of Dr. Yang's Ohio medical license and essentially gives him a second chance. Thank you.
Thank you, Mr. McGovern. Does the Assistant Attorney General wish to respond?
The Attorney General's office would defer to the report and recommendation. Thank you.
Thank you. Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Dr. Yang? Do I have a motion?
So moved,
Dr. Cockrell. Do I have a second?
So moved, Dr.
Johnson. Thank you. I'll now entertain discussion concerning the matter of Dr. Yang. Is there any discussion? Dr. Scheinstein.
Thank you. So, my thought as I read through this case and listening to the gentleman today is that I was actually reading two different cases. So in one case, which was substantially brought forth in the hearing and the R&R and today, is the case of a doctor who was caring for his patients in a responsible way, but who was directed to upcode his billing sheets by his employer, and the doctor acquiesced against his better judgment. The other case is located in Respondent's Exhibit B, substantially consisting of the pre-sentence investigation report, the U.S. Attorney charges, the plea agreement, and the attached statement of facts. Reading through the statement of facts as attached to the plea agreement, I found the behavior of Lindenwald Medical Associates to be brazen and audacious in its perpetration of healthcare fraud. So yes, there was upcoding, but there's also a charge that Lindenwald Medical Associates, and I quote, by and through defendant Yang and others known and unknown, close quote, would, quoting again, examine, close quote, approximately 40 to 60 patients per day, and that employees were directed to get in as many patients as they could and get them in and out of the office as quickly as possible, that many of these patients would receive at most a cursory examination to determine the extent of their pain level, and that many of these patients would leave the office with a prescription for a controlled substance, and that there was direction to the employees to give every patient a urine screen whether or not there was medical necessity for it. The results of the urine screens were not often reviewed by doctors at Lindenwald Medical Associates, if at all, until after the patient had left the office with a prescription for a controlled substance. Furthermore, the document reads that the employees were directed to bill for multiple units of urine screens when only one unit should have been billed. It is further charged that the employees were directed to alter dates in order to get claims for urine screens approved and to order diagnostic tests regardless of medical necessity. In testimony, Dr. Yang had indicated that he was promised kickbacks from the Lindenwald Medical Associates, but never received them. But I'll quote from the statement of facts as follows, quote, "The Lindenwald Medical Associates clinicians that ordered these tests, including Yang and others known and unknown, were provided kickback payments through the labs that processed the tests. Yang terminated his participation in the kickback payments early on because he did not feel right about it." Close quote. In testimony, the doctor had described his initial conceptualization of the upcoding as a victimless crime, but the scope of the fraud clearly had the potential for negative repercussions in terms of patient care. I would also say that it's hard to know the degree of the doctor's participation with regard to these additional behaviors because that was not elucidated at hearing. But he worked there for years. The clinic does not function without doctors. So at the very least, he aided and abetted this behavior on the part of the clinic. The doctor and his attorney signed the statement of facts containing these allegations and acknowledged them as true and correct. And at his hearing, the doctor was specifically asked about the statement of facts as to whether or not it was a true and accurate summary of what occurred and his level of involvement in what occurred, and he answered affirmatively. But he also went on to say that in his words, quote, "The biggest concern," close quote, regarding his own behavior was the upcoding. But he did not describe his upcoding behavior as the only concern. He described it as the biggest concern. That characterization implies the presence of other concerning behavior. So I perceive a discrepancy in the doctor's testimony. At the hearing, he was clear about the fact that he did not rush patients through or provide substandard care, and he was clear about the fact that he did not receive kickbacks, but the statement of facts that he signed suggests otherwise. The assistant U.S. attorney testified at the doctor's hearing and indicated that he was constrained in what he could talk about, but he did say, and I quote, "We prosecuted a number of individuals from that clinic over a period of time. That particular clinic had been a bastion of pill distributions for quite a while. Some involved Dr. Yang and some did not," close quote. So, gosh, the upcoding is bad enough, right? Upcoding is stealing, and in this case, it's stealing from the taxpayer because these are government-funded healthcare plans. The doctor's behavior brings the medical profession into disrepute. The cornerstone of the medical profession is the trust that patients and their families place in medical practitioners. They trust that they will be treated professionally and competently and ethically. The behavior of the doctor chips away at that trust. And by diminishing that trust, it diminishes the inclination of the public to seek out needed medical care. The doctor ignored his fiduciary responsibility to his patients. By engaging in behavior to artificially inflate the cost of medical care, this behavior went on for years. It was remote, but it went on for years. And so, gosh, it's regrettable. My inclination is that, especially given those additional concerns raised by the plea agreement and the statement of facts, it feels certainly like a bridge too far to me to, open the door to practice with a, suspension and conditions. And so I've sort of struggled about the revocation, whether or not we'd be right to, do a non-permanent revocation or a permanent revocation, or potentially even remand the case back to the hearing unit to try to get a, stronger sense as to the doctor's involvement in these other concerning behaviors. But, we do have our rule, right? We have, 4731.13.24, where a plea of guilty to or finding of guilt regarding a crime is evidence of commission of all aspects of that crime. And so conceivably, all elements of the crime have been conclusively proven. And so I'm not sure how much a remand would add to what we know. although I'm certainly glad to entertain it if board members feel like additional information would legitimately change how they would vote. I guess for me, I feel like as it stands now, and I'm glad to hear otherwise, I feel like it's a bridge too far to grant the license. And in that regard, I'll make a motion to amend the proposed order to a permanent revocation.
Any further discussion, Dr. Reddy?
I support that. As physicians, we have to be held at a higher standard than a common man. And in this case, there is certainly what Dr. Schottenstein was saying is proved beyond doubt. And I agree for a permanent revocation. I recommend permanent revocation.
Dr. Reddy, I'm sorry, can I just clarify, are you seconding Dr. Schottenstein's motion to amend?
Yes.
Very good. Thank you very much.
Thank you, Ben. Dr. Feibel?
I also agree with that. I don't need to rehash Dr. Schottenstein's eloquent testimony, but I agree with permanent revocation as well, given the facts.
Any additional discussion? So we have a motion by Dr. Schottenstein for an amendment for permanent revocation. It has been seconded by Dr. Reddy. And I'd like to now have a roll call vote on its merit. Dr. Rothermel?
Abstain.
Dr. Safran?
Abstain.
Sir Gacaloni?
Yes.
Yep. Dr. Soin?
Yes.
Dr. Schottenstein?
Yes.
Yes. Dr. Reddy?
Yes.
Yes. Dr. Caccarella?
Yes.
Yes, okay. Ms. Montgomery?
Yes.
Yes. Dr. Feibel?
Yes.
Yes. And myself, Dr. Bechtel, I'll have to abstain in this matter. Then it appears that the amendment has...
Dr. Bechtel, you didn't...
I'm sorry, Dr. Johnson, yes.
Yes.
Yes, okay, thank you. I apologize. So the amendment has been passed, and before voting on the motion to approve and confirm as amended, is there any further discussion? We'll have a roll call then. Dr. Rothermel?
Abstain.
Okay. Dr. Safran?
Abstain.
Okay.
I'm sorry, was there a motion to approve that as amended?
Yes.
Okay, I'm sorry, I apologize for the interruption.
Okay, no. Well, start the roll call again. Dr. Rothermel?
Abstain.
Okay. Dr. Safran?
Abstain.
Okay. Mr. Gacaloni?
Yes.
Yes. Dr. Soin?
Yes.
Okay. Dr. Schottenstein?
Yes.
Yeah. Dr. Reddy?
Yes.
Okay. Dr. Johnson?
Yes.
Dr. Caccarella?
Yes.
Yes. Okay. Ms. Montgomery?
Yes.
Okay. Dr. Feibel?
Yes.
And Dr. Bechtel, myself, I need to abstain. So the amendment passes. Thank you, Dr. Yang. You may exit the video conference now. If you wish to view the rest of the public meeting, it's being live streamed on the board's YouTube channel. Thank you. We'll now move on to proposed findings and proposed orders. In the following matters, the board issued a notice of opportunity for hearing, and no timely requests for hearings were received. The matters were reviewed by the hearing examiner, who prepared the proposed findings, proposed orders, and they are now before the board for final disposition. These matters were disciplinary in nature, and therefore the secretary and supervising member cannot vote. In these matters, Dr. Rothermel served as the secretary, and Dr. Safran served as a supervising member. We'll now turn the matter of Dr. Ho on. Please turn the matter of Dr. Ho on. Do I hear a motion to find that the allegations as set forth in the July 8th, 2020 notice of opportunity for hearing in the matter of Dr. Ah had been proven to be true by a preponderance of the evidence, and to adopt Ms. Lee's proposed findings and proposed order. Do I have a motion?
So moved, Dr.
By Dr. Coccarella. Do I have a second?
Second, Dr. Johnson.
Dr. Johnson. I will now entertain discussion on the matter of Dr. On. Is there any discussion? Seeing none, we'll go on for a roll call vote to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Dr. On. Dr. Rothermel?
Abstain.
Okay. Dr. Safran?
Abstain.
Mr. Coccoloni?
Yes.
Okay. Dr. Soin?
Yes.
Thank you. Dr. Schonstein?
Yes.
Yes. Dr. Reddy?
Yes.
Yes. Dr. Johnson?
Yes.
Yes. Dr. Coccarella?
Yes.
Yes. Thank you. Ms. Montgomery?
Yes.
Yes. Dr. Feibel?
Yes.
Yes. And myself, Dr. Bechtel, yes. We'll next turn to the matter of Chelsea Colombini. Do I hear a motion to find that the allegations set forth in the February 12th, 2020 notice of opportunity for hearing in the matter of Ms. Colombini have been proven to be true by a preponderance of the evidence, and to adopt Ms. Lee's proposed findings and proposed orders? Do I have a motion?
Yes, Dr.
Dr.
Johnson.
Johnson? And second, Dr. Coccarella. Thank you. I'll now entertain discussion concerning the matter of Ms. Colombini. Is there any discussion? Seeing none, I thought we'd go ahead and proceed with a roll call vote. This is a roll call vote to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Ms. Colombini. Dr. Rothermel?
Abstain.
Dr. Safran?
Abstain.
Mr. Coccoloni?
Yes.
Yes. Dr. Stein?
Yes.
Yes, thank you. Dr. Schonstein?
Yes.
Thank you. Dr. Reddy?
Yes.
Thank you. Dr. Johnson?
Yes.
Thank you. Dr. Coccarella?
Yes.
Yes, thank you. Ms. Montgomery?
Yes.
Thank you. Dr. Feibel?
Yes.
And myself, Dr. Bechtel, yes. We'll now turn to the matter of Khalid Jalil, MD. Do I hear a motion to find that the allegations set forth in the June 10th, 2020 notice of opportunity for hearing in the matter of Dr. Jalil have been proven to be true by preponderance of the evidence, and to adopt Ms. Lee's proposed findings and proposed order? Do I have a motion?
So moved, Dr. Johnson.
Dr. Johnson, do I have a second?
Second, Dr. Coccarella.
Dr. Coccarella, thank you. I will now entertain discussion concerning the matter of Dr. Jalil. Is there any discussion? Dr. Feibel?
I have one question, and this is my naivete, but he doesn't have a license, but we're revoking his license. Is that how does that work?
So the
Ms.
statute
Anderson?
allows the board to take action on an expired license. So that's what you're doing.
Thank you. Seeing no further discussion, I'd like a roll call vote to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Dr. Jalil. Dr. Rothermel?
Abstain.
Okay. Dr. Safran?
Abstain.
Yeah. Mr. Coccoloni?
Yes.
Okay. Dr. Soin?
Yes.
Okay. Dr. Schottenstein?
Yes.
Okay. Dr. Reddy?
Yes.
Thank you. Dr. Johnson?
Yes.
Okay. Dr. Coccarella?
Yes.
Yeah, yes, okay. Ms. Montgomery?
Yes.
Yeah, thank you. Dr. Feibel?
Yes.
Yes. And myself, Dr. Bechtel, yes. Please turn to the matter of Roganer, Lacerna, MD. Do I hear a motion to find that the allegations set forth in the November 10th, 2020 notice of opportunity for hearing the matter of Dr. Lacerna have been proven to be true by preponderance of the evidence and to adopt Ms. Lee's proposed findings and proposed orders? Do you have a motion?
Move, Giacalone.
Thank you, Mr. Giacalone. Second by Dr. Coccarella. I will now entertain discussion concerning the matter of Dr. Lacerna. Is there any discussion? Seeing no discussion, I'd like to go with a roll call vote to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Dr. Lacerna. Dr. Rothermel?
Abstain.
Thank you. Dr. Safran?
Abstain.
Thank you. Mr. Giacalone?
Yes.
Okay. Dr. Soin?
Yes.
Dr. Schottenstein?
Yes.
Thank you. Dr. Reddy?
Yes.
Thank you. Dr. Johnson?
Yes.
Dr. Coccarella?
Yes.
Yes, thank you. Ms. Montgomery?
Yes.
Thank you. Dr. Feibel?
Yes.
Yes. And myself, Dr. Bechtel, yes. Please now turn to the matter of Dr. Shamblin, MD. Do I hear a motion to find that the allegations as set forth on the May 8th, 2019 notice of opportunity for a hearing in the matter of Dr. Shamblin be proven to be true by preponderance of the evidence and to adopt Ms. Lee's proposed findings and proposed order? Do I have a motion?
Move, Giacalone.
Thank you, Mr. Giacalone. Do I have a second?
Second, Dr. Cockrell.
Dr. Coccarella. I will now entertain discussion concerning the matter of Dr. Shamblin. Is there any discussion in this matter? Mr. Giacalone.
Just given the amount of controlled prescriptions or substances prescribed, I think it goes without saying that this individual should be permanently denied a license here in this state.
Thank you. Any further discussion? I'd like a roll call vote now to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Dr. Shamblin. Dr. Rothermel?
Abstain.
Okay. Dr. Safran?
Abstain.
And Mr. Giacalone?
Yes.
Dr. Soin? Dr. Soin? I think you're muted there. Dr. Soin?
Yes. Are you able to hear
Thank
me?
you. Yes, thank you. Dr. Schottenstein?
Yes.
Thank you. Dr. Reddy?
Yes.
Thank you. Dr. Johnson?
Yes.
Thank you. Dr. Coccarella?
Yes.
Thank you. Ms. Montgomery?
Yes.
Thank you. Dr. Feibel?
Yes.
And myself, Dr. Bechtel, yes. We'll now turn to the matter of Venkata Rao Yaletti, MD. Do I hear a motion to find that the allegations set forth in the August 12th, 2020 notice of opportunity for hearing in the matter of Dr. Yaletti have proven to be true by preponderance of the evidence and to adopt Ms. Lee's proposed findings and proposed orders? Do I have a motion?
So moved, Dr. Cockrell.
Dr. Coccarella has moved in second.
Second, Dr. Johnson.
Thank you, Dr. Johnson. I'll now entertain discussion concerning the matter of Dr. Yaletti. Is there any discussion? Seeing none, we'll need a roll call vote to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Dr. Yaletti. Dr. Rothermel?
Abstain.
Okay, thank you. Dr. Safran?
Abstain.
Thank you. Mr. Giacalone?
Yes.
Thank you. Dr. Soin?
Yes.
Thank you. Dr. Schottenstein?
Yes.
Thank you. Dr. Reddy?
Yes.
Thank you. Dr. Johnson?
Yes.
Thank you. Dr. Coccarella?
Yes.
Okay. Ms. Montgomery?
Yes.
Thank you. Dr. Feibel?
Yes.
Yeah. And myself, Dr. Bechtel, yes. We'll now go to findings, orders, and journal entries. The following matters, in the following matters, the board issued notices of opportunity for hearing, and documentation of service was received for each. There was no timely request for hearings filed, and more than 30 days have elapsed since the mailing of the notices. These matters are now, therefore, before the board for final disposition. The matters are non-disciplinary in nature, so all board members can vote. We'll now turn to the matter of Marianne F. Bachmeyer, MT. On March 10th, 2021, the board authorized issuance of a notice of opportunity for hearing to Marianne F. Bachmeyer, MT, informing her that the State Medical Board of Ohio proposed to approve her application for restoration of her license to practice massage therapy, provided that she take and pass the massage and body work licensing examination, or the MBLEX. Due to the fact that Ms. Bachmeyer has not been engaged in the active practice of massage therapy for more than 2 years, do I hear a motion to find that the facts set forth in the March 10th, 2021 notice of opportunity for a hearing have proven to be true by preponderance of the evidence, and that the board enter an order effective immediately upon mailing for restoration of her license to practice massage therapy in the state of Ohio to be approved, provided that Ms. Bachmeyer takes and passes the MBLEX examination within 6 months of March 11th, 2021, the date of mailing of the notice of opportunity for a hearing. Do I have a motion?
So moved, Dr. Johnson.
Dr. Johnson? Second, Dr. Coccarella. Thank you. Is there any discussion in this matter? Seeing no discussion, we'd like to have a roll call. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Yes. Mr. Gaccalone?
Yes.
Thank you. Dr. Soin?
Yes.
Thank you. Dr. Schottenstein?
Yes.
Thank you. Dr. Reddy?
Yes.
Thank you. Dr. Johnson?
Yes.
Thank you. Dr. Coccarella?
Yes.
Thank you. Ms. Montgomery?
Yes.
Thank you. Dr. Feibel?
Yes.
And myself, Dr. Bechtel, yes. We'll now turn to the matter of Jason Fox, MT. On March 10th, 2021, the board authorized issuance of a notice of opportunity for hearing to Jason Fox, LMT, informing him that the State Medical Board of Ohio proposed to deny his application for a license to practice massage therapy because he does not hold a diploma or certificate from a school, college, or institution in another state or jurisdiction that meets the board's required course of instruction and hasn't held a current license, registration, or certificate of good standing for massage therapy in another state for at least the preceding 5 years. Do I hear a motion to find the facts set forth in the March 10th, 2021 notice of opportunity for hearing have been proven to be true by preponderance of the evidence, and that the board enter an order effective immediately upon mailing denying Mr. Fox's application for a license to practice massage therapy in the state of Ohio? Do I have a motion?
So moved.
Dr. Johnson, a second. Dr. Coccarella, thank you. Is there any further discussion concerning the motion? Go with a roll call vote. Dr. Rothermel?
Yes.
Thank you. Dr. Safran?
Yes.
Mr. Gaccalone?
Yes.
Yes. Dr. Soin?
Yes.
Thank you. Dr. Schottenstein?
Yes.
Yes, thank you. Dr. Reddy?
Yes.
Thank you. Dr. Johnson?
Yes.
Thank you. Dr. Coccarella?
Yes.
Thank you. Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Yes. And myself, Dr. Bechtel, yes. We'll now turn to the matter of Melissa K. Lecher. On March 10th, 2021, the board authorized issuance of a notice of opportunity for a hearing to Melissa K. Lecher, informing her that the State Medical Board of Ohio proposed to deny her application for a license to practice respiratory therapy or respiratory care because she had not successfully passed an examination approved by the board. The board requires respiratory care professional applicants to provide documentation that they have successfully completed both portions of the registered respiratory therapist or RRT examination administered by the National Board of Respiratory Care. The RRT consists of the therapist multiple choice or TMC examination and the clinical simulation examination or CSE. Ms. Lecher has not provided documentation that she has completed the required CSE portion of the RRT examination. Do I hear a motion to find that the facts set forth in the March 10th, 2021 Notice of Opportunity for a Hearing have been proven to be true by a preponderance of the evidence, and that the board enter an order effective immediately upon mailing denying Ms. Lecher's application for a license to practice respiratory care in the state of Ohio? Do I have a motion?
So moved, Dr. Johnson.
Thank you, Dr. Johnson. A second?
Dr. Cockrell.
Dr. Cockrell, thank you.
Yeah.
Is there, I thought we would go ahead then with a roll call. Dr. Rothermill?
Yes.
Dr. Safran?
Yes.
Thank you. Mr. Gacaloni?
Yes.
Dr. Soing?
Yes.
Thank you. Dr. Schottenstein?
Yes.
Thank you. Dr. Reddy?
Yes.
Thank you. Dr. Johnson?
Yes.
Thank you. Dr. Coccarella?
Yes.
Thank you. Ms. Montgomery?
Yes.
Thank you. Dr. Feibel?
Yes.
Yes. And myself, Dr. Bechtel, yes. We'll now turn to the matter of Brian James Steblings. Again, everybody can vote. On February 10th, 2021, the board authorized issuance of a notice of opportunity for hearing to Brian James Stebbings, informing him that the State Medical Board of Ohio proposed to deny his application for a license to practice respiratory care because he has not successfully passed an examination approved by the board. The board requires respiratory care professional applicants to provide documentation that they have successfully completed both portions of the registered respiratory therapist or RRT examination administered by the National Board of Respiratory Care. The RRT consists of the therapist multiple choice or TMC examination and the clinical simulation examination or CSE. Mr. Stebbings has not provided documentation that he's completed the required CSE portion of the RRT examination. Do I hear a motion to find the facts set forth in the February 10th, 2021 Notice of Opportunity for Hearing that proven to be true by preponderance of the evidence, and the board enter an order effective immediately upon mailing denying Mr. Stebbings' application for a license to practice respiratory care in the state of Ohio? Do I have a motion?
So moved, Dr. Johnson.
Dr. Johnson, second. Dr. Coccarella. Is there any discussion in the concerning motion?
I have a question, Dr.
Ms. Montgomery. Yes.
It's not related specifically to this case, but in the last case and this case, it's a two-part exam. I noted in the last case that they referred to when our applicant passed the multiple choice part of the exam, they referred to her as a certified respiratory therapist as opposed to a registered. And I wondered if that is a legitimate distinction, if those are recognized differences, and if there are different responsibilities. If so, I realize this is not necessarily on the Stebbings case, but I didn't jump in time on the last case. I apologize.
Ms. Anderson or Dr. Safran, I wonder if you could address that, or Mr. Alderson.
Mitch may be able to talk about that. Mitch Alderson. My understanding is in order to be eligible in Ohio, they have to take and pass the RRT examination, both portions, but Mitch can probably give you more detail.
Yeah, good morning. That is correct. To be an RRT or a registered respiratory care therapist, you need to pass both the TMC, the CRT and the CSE in order to be RRT. All these acronyms for you. So, and in order to sit for the CSE, you have to actually pass the TMC at a high enough cut score in order to sit for that CSE to then become RRT.
So there's no such thing as a distinction between there was a reference to it in the last case, as if there were an existing license or occupation that distinctly, if you only pass the multiple choice part versus the entire portion of the test.
The distinction is just, the difference between being a certified respiratory therapist and a registered therapist. So there is no distinction between like respiratory care practice professional licensure. It's just a matter of the two parts of becoming that RRT. And I hope I'm explaining that clearly for you.
I was just curious as to the difference. I don't want to waste people's time. So you can become certified, and does that have a set of obligations around it that is different than if you become registered and therefore a licensed RCP?
Right. So historically speaking, the TMC is primarily used to be considered the written exam. And so that's just, again, that's a different, portion or type of exam in order to pass that first and then, get that high enough cut score to then sit for the clinical simulation exam, which is a little different. It's a different, I hesitate to say it's a different standard, but the RRT is what.
I get that. I was just trying to figure out if there were different. If you're saying there are only words that are used in order to get to the ultimate licensure in Ohio versus whether there's a recognized set of responsibilities that if somebody who only passes half of it can do versus if they pass it all. And you're telling me apparently that's a distinction. There is no such distinction existent. I think that's what you're saying to us.
So currently in Ohio, you must be RRT in order to be licensed as a respiratory care therapist. Yeah, professional. That's correct.
Yeah. So, Mr.
Thank you.
The practical.
Thank you, Mr. Chairman.
Dr. Coccarello?
The practical consideration was in the old days, and the old days is probably defined by how old you are. So what you consider the old days, but in the old days, you used to be able to be hired by healthcare systems as a CRT, and the consideration was you were going to sit for this CSE, pass it within a certain period of time, and then everything was fine. Now you will not be hired until you have passed both parts of the exam. Unless you are an RRT, there is no one that will hire you in the state of Ohio. No health system or healthcare facility will hire you. So it's a practical consideration. Yes, you pass this exam, and I'm not sure why they have a designation for passing one exam where you really are not employable, but they have that designation. I don't know if the RRTs themselves, or wanted some recognition that they passed at least one exam, but you cannot be hired. You're not employable in the state of Ohio unless you are an RRT.
Thanks, Harish. That clear. Thank you, Dr. Coccarello. That clears it up for me. And
Sure.
thank you. Thank you.
Yeah, thank you very much. That really explains things well. So I thought we'd go ahead with our roll call vote. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Gaccaloni?
Yes.
Dr. Soin?
Yes.
Dr. Schottenstein?
Yes.
Dr. Reddy?
Yes.
Dr. Johnson?
Yes.
Dr. Coccarello?
Yes.
Thank you. Ms. Montgomery?
Yes.
Yes. Dr. Feibel?
Yes.
Yes. And myself, Dr. Bechtel, yes. We'll now turn to the matter of Carla R. Perry, RCP. On December 9th, 2020, the board authorized issuance of a notice of opportunity for a hearing to Carla R. Perry, RCP, informing her that the State Medical Board of Ohio proposed to deny her application of restoration of her license to practice respiratory care in the state of Ohio. Ms. Perry's denial is based upon former Rule 4761-8-01G of the Ohio Administrative Code that was in effect on December 9th, 2020, which required that a licensee that has been inactive for more than 5 years, if they've been inactive for 5 years, the applicant must either, one, provide proof of current licensure in another state, and standards for licensure are equal to those of Ohio, or alternatively, B, pass re-examination equivalent to the examination recognized by the board to originally obtain a license pursuant to Rule 4761-501 of the Ohio Administrative Code. In other words, the board requires applicants to successfully complete both portions of the registered respiratory therapist or RRT examination. Here, Ms. Perry was issued a license on August 26, 1999, which expired on June 30th, 2012. On or about September 26, 2020, she submitted her application for restoration of her license to practice respiratory care a period of time over 5 years, thereby bringing her into the purview of the rule. Do I hear a motion to find that the facts set forth in the December 9th, 2020 notice of opportunity for hearing have been proven to be true by a preponderance of the evidence, and that the board enter an order effective immediately upon mailing denying Ms. Perry's application for restoration of her license to practice respiratory care in the state of Ohio? Do I have any discussion first on this? Mr. Ellerson, do you want to comment on this rule at all?
Not unless there are any questions about the rule. It's the old rule. It's the 5-year lapse rule that, of course, no longer exists. So unfortunately, she did submit a restoration application prior to that change. It might be important to note that should she, had submitted her restoration application today, she unfortunately still would not be eligible because she is not on RRT, if that helps.
Dr. Coccarella, do you want to comment?
No.
Okay, thank you. So we'll go ahead with the roll call. Dr. Rothermel?
Yes.
Dr. Saffron?
Do we have a motion and a second on this one?
Oh, I'm sorry. I apologize.
No, I didn't have it, so.
Yeah, so moved.
Dr. Coccarella, second? We have a second?
Second.
Dr. Saffron, thank you. Roll call. Thank you, Ms. Anderson. Dr. Rothermel?
Yes.
Dr. Saffron?
Yes.
Yeah. Mr. Gacaloni?
Yes.
Yeah. Dr. Soing?
Yes.
Right. Dr. Schonstein?
Yes.
Yeah. Dr. Reddy?
Yes.
Thank you. Dr. Johnson?
Yes.
Thank you. Dr. Coccarella?
Yes.
Thank you. Ms. Montgomery?
Yes.
Thank you. Dr. Feibel?
Yes.
And myself, Dr. Bechtel, yes. I will now entertain a motion to go into executive session. Following the executive session, the board will take a 20-minute recess before resuming business, which is good. Do I hear a motion to go into executive session to confer with the medical board's attorneys on matters of pending imminent court action and for the purpose of deliberating on proposed consent agreements and exercise of the medical board's quasi-judicial capacity and to consider the appointment, employment, dismissal, discipline, promotion, and demotion of or compensation of a public employee or official? Do I have a motion?
So moved.
Dr. Saffron, second. Dr. Johnson. Roll call vote. Dr. Rockingham.
Yes.
Dr. Saffron.
Yes.
Yeah. Mr. Cacalone?
Yes.
Dr. Soin?
Yes.
Dr. Scheinstein?
Yes.
Dr. Reddy?
Yes.
Yes, thank you. Dr. Johnson?
Yes.
Yes. Dr. Coccarello?
Yes.
Yes. Ms. Montgomery?
Yes.
Nothing. Dr. Feibel?
Yes.
Thank you. Myself, Dr. Bechtel, yes. And I think Ben will need to reconnect to a new link, I think.
This conference is no longer being recorded.
Yes, that is correct. If everyone can log in on the link I sent for executive session, I'll see you on the other side.